We are here today on our case number 1CACV170524, Cenite versus Carter Burgess et al. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it. The clock on the podium will reflect the total amount you have, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you both if you would, when you approach the podium, give us your name and the name of your client. We've studied the briefs in the case and the record. We've also discussed the case in our conference. So with that, Mr. Treon, you can proceed.
Good morning, Your Honors. Richard Treon, on behalf of the plaintiff appellant, Dolan Cenite, and by and through his mother, Barbara Cenite, who is his conservator. We're here today to ask this court to reverse the decision of the trial court in granting summary judgment on the issue of collateral estoppel. That's what the case is about, the issue of collateral estoppel. The trial court found that in Cenite 1, where, as you know, we sued the city of Phoenix and claimed that the city had been negligent in the manner in which they had failed properly to perform their job as the entity responsible to make sure that negligent designs, intersection problems, traffic engineering issues were not created by planners who brought their plans to the city. It was the city's job as the entity that owned the roads to make sure they were safe. And in that case, of course, the jury found against us. We appealed. This court affirmed. And then we sued these defendants, the developers and the designers of the intersection where the where the negative offset had been created. The issue on appeal is whether these defendants have met their burden, because it is their burden, of proving that collateral estoppel should apply in this case. And we agree on the standard of law relating to collateral estoppel as articulated in the briefs. And essentially, for our purposes, they relate to two issues. One was the issue of negligent design of the intersection actually litigated in Cenite 1? And two, if it was it essential to the jury's general verdict in favor of the city finding no liability? It's a plaintiff's position that the issue of negligent design of this intersection was never an issue at all in Cenite 1, and frankly, we challenge these defendants to provide to this court any evidence that the issue was litigated. The issue that we tried to litigate, as is clear from our briefs, is the issue whether the city was negligent in performing its duty to make sure that their approval in the design process was proper and that they did not approve an improper design. The court, and I'm not going to deny the fact that initially there's a whole lot of things in the litigation that talks about negligently designed intersection, but the issue is not what's in the papers generally. The issue is what was litigated. What was litigated is what Judge Rea told us was going to be litigated, because he rejected my argument that the way you prove a case of this type is to show that the city was negligent because they're the defendant. And instead, he set up a standard of proof that we had to prove that the intersection was unreasonably dangerous. Now, in a situation
that was because of the poor design, correct? I mean, was there some circumstance beyond the poor design that made the intersection likely unreasonably dangerous?
Your Honor, the issue of unreasonable dangers has nothing to do with the issue of whether or not the intersection was negatively designed. That's the trap that the trial court fell into here in this case. And you have to go back to the beginning here and understand. They didn't argue that the plaintiff's burden of proof in order to show in the city case liability was that the intersection was negatively designed. The way that unreasonably dangerous came in the case is because the city raised the defense of 12-820.03, which says that the city, if they did their design if the city approved a design that was in conformance with then generally acceptable engineering and design standards, then the city couldn't be held liable unless, provided, however, actually is what the statute says, there is an unreasonably dangerous condition and the city fails to warn. Judge Rea, for some reason, got off on the track that this was a failure to warn, unreasonably dangerous case under 820.03. When it wasn't, it was a case about the city and its conduct and the manner in which it reviewed the plans and then agreed to allow them to be built based upon a finding that was actually contrary to their own standard drawings, but that's another issue from a different case from the prior Senate 1. The idea that the issue of negligent design was actually litigated in Senate 1 because of the fact that the instruction the court gave had to do with whether or not it complied with the then acceptable standards that the city had met in the engineering and design standard. If the case had been an instruction to the jury saying that the standard that you're applying in this case is, did the design that the city approved comply with the engineering and design standards then and there applicable? If that had been the instruction that had been given, we wouldn't be here because we wouldn't have an argument. But what he did was he took the unreasonably dangerous out of the warning section, had nothing to do with the plaintiff's burden of proof, and put that burden of proof on us in the instruction, which is contained at page 8 of the opening brief.
So your argument is that the court that in the current case, the obligation of the plaintiff would be to prove that the design did not comply with generally accepted engineering and design standards in effect at the time.
Your Honor, our obligation would be, it's a little bit difficult to know for sure what the standard would be because in a sense that's almost like a malpractice standard of care kind of a standard. My position is that in this case against these folks, if we ever get there, I have an obligation to prove they failed to act reasonably and prudently under all the circumstances relating to the design of this intersection, and the creation of a negative offset is not reasonable and prudent. Now, do I have to go forward and show that that's generally accepted design? I suppose that they would come in with their experts, and their experts would say that this is not required, or my experts would say it is required, but I don't know that the judge would instruct the jury that I had to prove that there was a standard of care that existed at that time. The standard of care part of this issue in this case came up from their statute with the city. That statute is solely related to the city's liability. The city gets that as not an immunity, but as a defense, although it's an immunity section of the code. And so anyhow, it may well be that I may have to meet that standard as you articulated, but I would argue against it, as is my nature.
Let's just say that in a malpractice case or a professional negligence case against a design professional, the plaintiff needs to prove that the design did not conform to generally accepted engineering or design standards in effect at the time.
Okay.
As I understand your brief, what the instruction that Judge Ray gave at the time added into that another element, required you to prove also that the intersection, as a consequence of its failure to comply with the then current standards, as a consequence, the intersection was unreasonably dangerous.
That's correct, Your Honor. And it was not just a change; it was a paradigm-shifting change.
But is it really? I mean, when you're talking about a design standard that is aimed at safety, doesn't the breach of that design standard necessarily result in an intersection that's unreasonably dangerous? The
concept of unreasonable dangerousness is unknown to tort law, Your Honor. Where else in any statute, any instruction, any aspect of the law does it say that a plaintiff has to prove in order to win a tort case that something was unreasonably dangerous? The fact that it may or may not be implied or assumed or inferred has nothing to do with the fact that Judge Rea told the jury, this is the law. The intersection was, plaintiff must prove the intersection was unreasonably dangerous because of planner design, etc. Then he went on to say, not just that, but also the intersection was unreasonably dangerous because the signal light was not programmed for left turn on green arrow only, which had nothing to do with the issue of the negligent design of the intersection. But what he's doing is he's superimposing on our negligence standard that we have to prove normally, a standard of by having to prove the intersection was unreasonably dangerous, which is not the law. Most importantly, though, that issue was the issue of negligent design was not ever litigated in the underlying case, and that's the only way they can bring collateral estoppel into this case.
Well, I remember a lot. I happened to sit on the appeal, and I remember I thought a lot of interesting design issues about carrots and offsets being offered to the jury.
Right.
So that wasn't litigated? I mean,
well, actually, if you recall, the carrots and offset were not allowed to be told to the jury because Judge Rea had decided that I had not disclosed Dr. Lyle's opinions in that regard, despite the fact that he presented to the city a design showing exactly where the the carrots and the painted lines and the channelization should go. His deposition was taken by defense counsel. She decided, I'm not going to ask him about these arrows and this paint and these channelizations because I didn't think he knew what he was talking about. And that was the heart of our argument on appeal as to why the court's failure to, of course, blocking Dr. Blau from being able to explain the design issues was wrong. This court basically said, okay, well, maybe she shouldn't have done what she did, didn't quite find that there was a disclosure problem, but then went on to say it didn't make any difference because plaintiff had an opportunity, was not prejudiced, to argue that it wasn't dangerous. But we're right back then in the soup then of unreasonable dangerous, which has never been in this case. This court said, at paragraph 10 of its opinion, we need not decide whether the court abused its discretion in granting the motion in limine related to discovery because Cenite cannot show that the ruling prejudiced her. Cenite's negligence claim required proof that the city's intersection design was unreasonably dangerous. And right there, Your Honor, makes my case, frankly, I do believe, because what you're saying is that in order to prove the city's liability, I had to prove not that the intersection was negligently dangerous, which is what negligently designed, which is what they say, but I had to show it was unreasonably dangerous, a concept unknown to the law for tort plaintiffs, and only in this case because Judge Rea, for whatever reason, liked that 820-03 and brought it in the case. And frankly, in retrospect, I was wrong in not putting that in as an issue on appeal, frankly. I should have. And at least I was bothering you with the other 6 issues you had to work through. But, I mean, that's the heart of the matter. They can't get to collateral estoppel. Stop and think a moment, what's collateral estoppel? These people never saw the courtroom in Cenite 1. They were not defendants. They were not non-parties at fault. They never were asked to do any discovery. They were complete strangers to the case. Now they want to come in and say that because another jury in another case on another issue found against Cenite's, therefore, that insulates them from liability for what they did to create the dangerous conditions in the first place through their negligent design. And my argument is that the law says to apply collateral estoppel, it has to actually be litigated. It's not actually litigated. Negligent design of the intersection, where the other case had as a standard that I had to prove that the intersection was unreasonably dangerous, as well as that it didn't comply with the underlying design and statutes, etc., as outlined in Judge Rea's instruction. And in addition to which, Your Honor, it was a general verdict, and the verdict is simply was favored to the city. They have to prove that the decision by the jury in rendering that general verdict was because they had found essential to their decision that this intersection was not negligently designed. How do they get there? It's all inference, it's all surmise, it's all conjecture, it's all logical syllogisms.
It seems like if the instructions had been broken out like they normally are, in other words, if the court had instructed the jury in your first case that the plaintiff has a duty to show that the intersection was not designed in accordance with generally accepted standards.
That wasn't our burden.
Fell below, well,
That's their defense.
if the court had instructed the jury, the plaintiff had a duty to show that the design of the intersection fell below the standard of care, and then had instructed the jury, if the plaintiff makes that showing, that the city may still win if you find that, and then recited the language of the immunity statute.
That's a hodgepodge of confusion and chaos, Your Honor. It has nothing to do with the law. Is that usually we follow Rajis, and Rajis say whether they failed to act as reasonable and prudent designers and contractors or owners at the time that they created the intersection with the negative offset. But that wasn't even the case as presented to the court. You go back and read the dialogue between me and Judge Rehab in pages 10 and 11. Every time I tried to go back to the point of my duty is not here to show anything other than the fact the city was negligent and the manner in which they performed their duty to approve these plans or not approve these plans, and that they violated that duty because they allowed the intersection plans to be accepted that created a negative offset in contrary to their own design drawing, which was that they're supposed to follow. And Judge Ray basically said, I'm wrong. That's not the issue. In fact, in several places here, he says that, 3 or 4 places, he says that it's all about whether or not it was unreasonably dangerous. He says that, what difference does that make when I'm trying to argue to him about this standard I just articulated? I mean, it's either unreasonably dangerous or it's not. What does that have to do with negligent design? And if it's unreasonably dangerous, what difference does it make who approved the plans or whether anybody approved the plans? I got switched right out of a case against the city into some kind of a crazy standard on unreasonable dangerous that had to do with the city's defense that comes out of the defense statute as part of the immunity code. He goes on to say, they could have bungled the whole approval process, but if the intersection is not unreasonably dangerous, the city is not liable. Unreasonably dangerous, again, is the standard he's going to apply. But I says, Your Honor, it's their negligence and failure to perform their job as a gatekeeper of developers who come in with their plans and design, a negative offset created in both situations, and then the city is negligent in failing to say, wait a minute, you can't do that in the city of Phoenix. That's what I told him. I thought my burden was to prove my case against the city of Phoenix. He then comes back to say, well, if the jury believes that the intersection was unreasonably dangerous, then the city is liable. I mean, does the city argue differently? And of course, the city council will say, of course, no, we don't differentiate with Your Honor what you're saying. That's a standard we like even better than what we have to prove. It goes on to say, the court, so then, it doesn't matter how it got to be unreasonably dangerous. And if it doesn't matter how it got unreasonably dangerous, what the heck does negligent design have to do with it? It's all about unreasonably dangerous. I should not have said negligent design. I should have said it has to be unreasonably dangerous. And that's how the case was presented to the jury. They came back with a general verdict. And, okay, so that's the net one. It's over and done with. But now they want to come in and they want to take what happened back there and say that proves that they didn't do anything wrong because some other juries already said they didn't do anything wrong. Where does it say it? Nowhere. They can't. You just have to go through all kind of inference and surmise and conjecture to get there. And the trial court tried to do a logical construct about trying to say about, well, you go here, then you got to be there. But that's not proving something's actually litigated. It's their burden to prove it was actually litigated and that the jury's decision in Cenite 1 was essential to the determination that the jury in Cenite 1 decided it was a negatively designed intersection. They didn't even get there. I'll reserve the rest of my time then. Thank you.
Good morning, Your Honors. My name is Luann Rosen, and along with Renee Nachman, I represent Tremano Development, LLC. And also with us today are Jody Mullis for Carter Burgess, Lauren Shapiro and Netta Gales for Sonoran Foothills, Inc., Will Breyer for Stephanie Kinsey and DEI Professional Services, LLC, and Andrew Apodaca for Richard Hopp. And certainly if the court has questions for any specific defendants, I'll be taking the lead on the argument, but if you have specific questions for specific defendants, they're ready to answer those as well. So, Your Honor, there is only one issue in this case, which is whether the trial court erred in granting summary judgment for the defendants on the basis of collateral estoppel. And we do agree on the elements of a collateral estoppel or issue preclusion apply here. And the defendants believe that all of those elements are met. The first element is whether the parties actually litigated the case in Senate 1. And there's three elements to that particular element. The first one is that the issue of negligent design and construction of the intersection was properly raised in the pleadings and otherwise in Senate 1. And if you look at the plaintiff's complaint in Senate 1, they make allegations that the city was responsible for the design, construction, and maintenance of the intersection. The city had a duty to use reasonable care in the design, construction, and maintenance of the intersection. And through their employees and agents or independent contractors to whom they owed a non-delegable duty, the city was negligent in the design, installation, construction, and maintenance of the intersection, and they designed the intersection in a manner not in accordance with acceptable highway engineering standards. In other pleadings in Senate 1, as the trial court in this case pointed out, plaintiff in their response to the city's MSJ said that plaintiffs alleged the city negligently designed the intersection when it was built in 2005 and 2002 and again in 2005, and negligence design was a cause of the collision. In their motion to consolidate, plaintiffs said that they sued the city alleging the city negligently designed and constructed a dangerous intersection. And in plaintiff's response to the city's motion to quash a subpoena, plaintiffs said the claim against the city included negligent design and construction of the intersection based upon the opinion of plaintiff's expert Robert Blyle. After a 6-day jury trial resulting in a unanimous verdict, assembly of my words, for the city, plaintiff appealed to this court and lost on the appeal. In its memo decision, this court acknowledged that plaintiff's case against the city was based on negligent design and construction, stating that the plaintiff sued the city alleging negligence in the design, installation, construction, and maintenance of the intersection, and that expert Blyle's report asserted the intersection was negligently designed, and that plaintiffs needed to show only that the intersection was negligently designed in order to get to that unreasonably dangerous burden that plaintiff is talking about. When you compare it to the allegations in this complaint, they're pretty much exactly the same. In this, we've included as Appendix C, I believe it is, to our brief. In paragraph 6 of the complaint against these defendants, they say defendants Carter Burgess, Tremonto, CMX, DEI, and Sonoran Foothills each acted negligently in designing the left turn bays. In addition, defendants failed to coordinate the design of the separately designed and in turn left turn bays, thereby setting up a situation where the negative offset would be created. In addition, defendants knew that the highway was heavily traveled and that vehicles drove at a high rate of speed, and that a dangerous condition was created for the through vehicles. Despite this knowledge, defendants were negligent in submitting and having the city approve the designs for the left turn bays, and then by installing the negative offset. And then as a result of the negative offset, the driver who turned in front of Mr. Cenite was confused by the dangerous and defective negative offset of the intersection. And finally, the negligent design, construction, and improper signalization created by the defendants acting alone or in conjunction with the other defendants caused or contributed to the accident. So it's clear that, at least in the pleadings and otherwise, the issue of negligent design and construction at this intersection was at issue both in Senate 1 and in the complaint against these defendants. It's also true that the issue of negligent design and construction was submitted to the jury in Senate 1. The crux of plaintiff's case is that the negligent design was not submitted to the jury, but rather the jury determined whether the intersection had to determine if it was unreasonably dangerous. But then you get back to that jury instruction. The jury instruction says that the plaintiff and Mr. Tran did not appeal from the jury instruction in Senate 1. And quite frankly, I know in his brief he said I was accusing him of malpractice, but that's not the case. I don't think he would have won that argument in Senate 1. I think that in Senate 1, the Judge Rea got it right, that what he needed to prove was not that the city negligently approved the design, because if there was nothing wrong with the design, it wouldn't matter what they did with the approval process.
What instruction would the jury be given in this case?
In this case, I think that they would need to prove that the intersection was not unreasonably dangerous, that the defendants negligently designed the intersection because it was not in conformance with the generally accepted engineering and design standards.
So that would be the standard of care that the court would define as applied here. In other words, that the defendants had a duty to design the intersection in accord with what?
With the engineering standards in effect at the time that it was
The
designed.
standards. Okay.
Yes.
As I understand the argument, though, the jury in the prior case was instructed, rightly or wrongly, as to that, but also was instructed that it could fine for the plaintiff only if, as a result of failure to comply with the standard of care, the result was an unreasonably dangerous intersection.
Well, I think that I look at it a little bit differently. I think that the way to prove it's unreasonably dangerous is that you prove one of those other two things. Either the signals were they're out of this case,
yeah,
right,
yeah.
Or that it was negligently designed, which is one of the ways that would make it unreasonably dangerous.
But the argument goes the other way here. I think to apply the doctrine of collateral estoppel, we would have to find that a negligently designed intersection is, as a matter of law, unreasonably dangerous.
I think that is.
So what have you got for me on that?
Well, what I have for you on that is that the only way to get there is to find that the intersection was negligently designed. And the jury in this case did not find for the plaintiffs, which means that they necessarily had to have found that there was not a negligent design of the intersection.
What cases tell us, or what Rajis tell us, that a consequence, in a case like this, where safety is at issue, and the consequence of a negligent design is an unreasonably dangerous intersection?
Well, I don't know a Raji right off the top of my head that would say that, but I also do note in the plaintiff's complaint against these defendants, the plaintiff also said that the result of the negligent design is what made this intersection unreasonably dangerous.
But the issue is what the jury found in this case, not what was alleged in the complaint, what the jury was instructed and what the jury found.
Well, I think what the jury found in this case, because it was a general verdict and plaintiff didn't poll the jury or ask for special interrogatories as to what the jury actually found, I think you have to, with that general verdict, say that every essential issue was found by the jury. So the jury either found that the intersection was not, well, the jury would have found all these things. The intersection was not negligently designed, the signals were not improper, or if they found one of those two things did occur, then they found that was not the cause of the accident.
But couldn't the jury under this instruction, couldn't the jury have found for the defense because it found that the intersection was not unreasonably dangerous?
I don't believe that you can get to the unreasonably dangerous unless you get to the reasons that the trial court instructed them of what creates unreasonably dangerous condition. So I think that for the jury to have found the intersection was unreasonably dangerous, it would have had to have found one of those two reasons. The court, it says the intersection is unreasonably dangerous because the plan or design of the left turn bays is not in conformance with the generally accepted engineering standards, or it's unreasonably dangerous because of the signalization.
Take out the signalization. What I understand Mr. Treon to say is that under this instruction, the jury could have found that the intersection was not unreasonably dangerous and could have stopped right there without addressing whether it was unreasonably dangerous because it didn't conform with the standard of care.
Well, I don't think that's true for how the jury was instructed.
Well, I've got the instruction right here in front of me. The intersection was unreasonably dangerous because the plan didn't conform to the standard of care.
So if the plan didn't conform to the standard of care, that makes it unreasonably dangerous.
Well, in that case, then the jury would have to find for the plaintiff. But what if?
And they didn't.
Right. But I think read fairly, the instruction allows for the possibility that the intersection was unreasonably dangerous for some other reason, or the intersection was not unreasonably dangerous at all, so we don't need to get to the standard of care. That's his contention.
I understand that's his contention, but I'm not sure how you get there with this particular way that the jury was instructed. The only way that the jury could find that the intersection was unreasonably dangerous is one of those two circumstances. Either the signals were bad and that's out, or it was negligently designed and constructed. And the jury didn't find either of those to be true for the fact that it found for the defendants. And I suppose the third option is that they decided that it might be that a better design might have been, there could be a better design for that intersection, but that wasn't the cause of the accident. That's also something that the jury could have decided. And we don't know what the jury decided because this is a general verdict, so you have to determine that the jury determined each fact.
Well, and the burden's on the defendants to show that here.
Well, yes, but with a general verdict, you have that as the presumption. It's
Sure about that.
So, as I understand the argument, the concept of unreasonably dangerous isn't free floating in the instruction. It's tied to the two options.
Yes, I believe that it's tied to the two options. I don't think it's separate. So I think you have one of those two options to get to the unreasonably dangerous condition. And again, even though I don't think he would have won on the issue if he had appealed from that, because he didn't appeal from it. So this jury instruction stands. The judge in this case, Judge Rogers, was right to look at this jury instruction, and I believe he made the proper analysis that based on this jury instruction, the only way to have found for the plaintiffs is to find that either the signals were bad or the intersection was negligently designed.
So you don't think that the jury in this case could have found that it was negligently designed, but not so bad as to cause it to be unreasonably dangerous?
I don't know that I would agree with that. I think they could say maybe there was a better way to design it, but that's not what caused the accident. So I think that is the reason.
Take causation out because causation is going to be an element of this in this case. So I don't care about causation. My question is whether do you think that this instruction allowed the jury to find that the intersection did fall below the standard of care, but that it was not unreasonably dangerous?
No, I don't. I think the only way for it to find. No, I think that if the jury had found that the way that the jury was instructed, if it found that it fell below the standard of care, then it needed to find that it was unreasonably dangerous because of the way they were instructed. You need to prove unreasonable dangerous because one or two, and they didn't.
Something else.
Well, they weren't instructed on anything else.
That's the point, I guess. I think what the plaintiff argues is that the jury allowed for some other possibility.
Well, again, that may be true, but that is an issue in Senate 1, and that is something that the plaintiff didn't appeal from in Senate 1. So you have many statements in the memo decision in Senate 1 that this was a negligent design case, a negligent design and construction case. You have the two competing complaints, if you will, that have almost identical language. And both of them are seeking to find that a cause of this accident was a negligent design of the intersection. I think that was decided by the jury in Senate 1. I think it was submitted to the jury. I think the jury, in my opinion, was properly instructed. I don't think that it was an approval case at all. I think the jury or the judge in Senate 1 was correct that it wouldn't have mattered how badly the city bungled the approval
It had to be
process.
negligent,
Yes,
a negligent design to begin with.
correct. We did make some other arguments. I could go in on the public policy reasons that support this, if you have questions on that. It sounds like you don't want to hear about causation. We do think that's another, I think that the jury could have found, we don't know, because again, it was a general verdict, the jury could have found that there was lack of causation because
But
of how
don't you
this
win
accident
then, if
occurred.
that's the case?
I believe that we do. I think that is also collateral estoppel.
Yeah,
I think causation was submitted to the jury. In fact, Mr. Trian's closing statement to the jury in Senate 1 was, so if we prove to you, to your satisfaction, by what we call the preponderance of the evidence, our evidence outweighs their evidence, that this intersection was unreasonably dangerous because it had a negative offset out there, it violated the applicable traffic engineering and design standards, then the city would be liable if you find that was a cause of the accident. So that was submitted to the jury as well. And the jury came back, unanimous verdict for the city, so it
Either
didn't.
it found no negligence or no causation.
Correct. Any other questions for me? See, do you guys have any other points? Address?
We're good?
Okay, thank you.
Thank you. Thank you.
Your Honor, it's nice to hear all my pleadings read back to me, and I only wish the case were back at that stage at times so I could do differently than what I did then. However, that has nothing to do with what we're talking about here. That doesn't describe what was actually litigated. That's what I was trying to plead and where I was trying to get. What was actually litigated is contained in our brief. I quoted verbatim what Judge Ray had to say, and he set the standards only about unreasonable dangerousness. That's all this case is about. 4 different times he said it. Then he put it in instruction. So that's...
So that, I mean, your argument is that unreasonably dangerous is not necessarily tied to the negligent design, and the instruction ties the two together.
Precisely.
The jury, I have trouble reading the instruction to say the jury could have found that was unreasonably dangerous for some other reason other than the negligent design.
Well, Judge, let me ask you this. Where has the defendant pointed out to you, or sorry, the defendant in this case, pointed out to you that in Cenite 1 the jury was ever instructed on the issue of negligent design in and of itself as a separate issue to be decided? They were never told that. They were told in this combined, cobbled together defense quasi-immunity statute, what they were told about, you got to find it was unreasonably dangerous. And that is a concept unknown to law. Her Honor hit it right on the head when she said, are you saying to me then that if you find this negligently designed as a matter of law, it's unreasonably dangerous? They can't answer that because it doesn't exist. You can't, negligence does not equal unreasonably dangerous. If that were so, it'd be in a Raji somewhere. Judge Leah put a wild card into this deck and totally shuffled it in a way that very badly hurt the plaintiffs. And as I said, in retrospect, I wish I would have appealed on that issue. I didn't. That didn't make any difference, though, because the issue is what happened in Cenite 1 and whether or not they can now pick up Cenite 1 and apply to this case. I would just say finally, with respect to counsel's argument that, well, because it was a general verdict from the jury, that sort of closes the case for the defense. It doesn't. I cited in my reply brief the law relating to what happens where you have a general verdict and where you have issues regarding instructions. And the instruction here was not the appropriate instruction, wasn't found to be that because I did an attack on an appeal. There's no way that the instruction that Judge Rea gave was an appropriate instruction for this case, Cenite 1, as it should have been.
Okay.
And based on the cases I cited at page 14 and 15 in the reply, can't draw that inference.
Thank you.
Thank you.
Thank you to everyone for your argument and for your briefing. We'll take the matter under advisement and issue a decision in due course. Now we will adjourn.